Good evening to all and welcome. My name is Alexandros Dovas. I'm an associate professor in maritime law at the University of Southampton Law School and the director of the Institute of Maritime Law. At the time when I came into the position of the director, the spread and pace of the coronavirus disease started steadily to evolve into what now, unfortunately, has been raging as a full-scale pandemic, with unprecedented impact on the global population and the world economy. However, against the ongoing adverse conditions, the Institute has been adapted immediately to the new circumstances and remains undeterred from the aim of being a major center for research, study, and dissemination of maritime law, enjoying an international reputation for excellence. One of the many testaments of our commitment to this end, I believe, is evident this evening as we pressed on with our plans to hold virtually the 38th installment of the Institute's annual lecture. And we are delighted to welcome the Honorable Mr. Justice Foxton as our speaker. In closing my short introduction, I wish to acknowledge with appreciation and express the gratitude of the Institute for the generosity of our sponsors, Ince and Informal Law, and to take this opportunity to draw your attention to the formal release of our annual report that will be available from tomorrow morning on the Institute's website. The report will come to you at a time when the whole world remains shrouded into the uncertainties of the pandemic. And therefore, I wish that all of you will remain healthy and strong in your family, profession, and our society, while our humankind is facing fundamental changes. I thank you all for joining us this evening, and without further ado, I shall pass now the floor to the chair of the annual lecture for this year, Mr. Julian Clark, who will introduce our distinguished speaker.
Thank you, Alexandros. My lords, ladies and gentlemen, members of the faculty, members of both branches of our honoured profession, distinguished guests, and especially this evening, Beryl and Neil O'May, that I know are joining us on this virtual presentation. It is my great privilege and honour this evening as the 10th senior partner of Ince to chair the 38th Donald O'May Lecture. Indeed, 2020 is a year of anniversaries, with Ince celebrating its 150th year and our commercial court celebrating its 125th year. And in fulfilling this role in introducing tonight's speaker, the Honourable Mr. Justice Foxton, I cannot personally think of a prouder time since my own call to the bar in 1988. Now, that year is one which will always be foremost in my mind, not only as the year of my call and my entry into this maritime sector, which has been my home ever since, but also as the year when we lost the man after whom these lectures are now named, Donald O'May. Donald became the 4th senior partner of the firm in 1976, following the retirement of Jack Griggs. And over the next 12 years, he navigated the firm through the difficult waters of being a medium small to a medium large legal practice. Like his mentor, Jack, Donald soon gained a reputation in the maritime insurance and commercial community as the foremost amongst the lawyers in the marine insurance market. Indeed, it was another one of our past senior partners, Peter Rogan, that I also know is in our audience tonight, that reminded me that it was Donald that through his brilliance and leadership facilitated the arbitration of the Bamburi before Mr. Justice Thornton, as he then was, sitting as an arbitrator, which became the test case for the 70 vessels trapped in the Shat al-Arab as a result of the Iran-Iraq war. And it was this and a series of other second-generation post-war scuttlers and incidents following the Indo-Pakistan War that earned Donald the title, the King of War Risks. And I'm delighted that these lectures will now continue in his honour. And I know that Donald would be delighted to have with us tonight such a distinguished, accomplished and talented speaker. The Honourable Mr. Justice Foxton was called to the bar by Gray's Inn in 1989, and he practised as a member of Essex Court Chambers for over 30 years, for the last 3 as the head of chambers. There, his practice embraced a broad range of commercial disputes, including those arising from shipping and international trade. He was sworn in as a judge of the Queen's Bench Division in January 2020 and sits in the Commercial Court. He is the General Editor of Scrutton on Charter Parties and has published a biography of Lord Justice Scrutton. It is our pleasure, sir, to have you with us this evening. May I hand over to you?
Julian, thank you very much for that very warm introduction. It is my great privilege to have been asked to deliver the 38th Donald O'May Lecture, organised by the Institute of Maritime Law at Southampton University and sponsored by Ince and by Informa Law. This is the first of those 38 lectures to have been delivered wholly remotely, and I'm sure we all hope that it proves to be the last. I'm acutely conscious that I follow a set of far more illustrious predecessors, and I can only hope that, like Flotsam and Jetsam, I am dragged along in their wake. My personal engagement with shipping law began inauspiciously. In 1988, as Sir Bernard Eder's pupil at what was then 4 Essex Court, I attended a conference with the future Lord Thomas of Cwmgïeth. At the start, he introduced me to a number of men, and I'm afraid they were largely men in those days, who he told me were from the west of England. Now, I had no idea what a P&I club was, and so I proceeded to share my memories of growing up in Taunton. I soon found that I'd entered a world where the west of England meant something far removed from scrumpy on a Sunday afternoon and Ian Botham hitting sixes out of the county ground. The prospect that I would ever have delivered the Donald O'May Lecture must have been vanishingly remote. The title of this lecture was originally going to be, Does Shipping Law Still Matter? But as the lecture is one of the great occasions in the maritime law calendar, named in honour of one of the most distinguished and highly regarded of maritime solicitors, and as this year's lecturer is the General Editor of Scrutton on Charter Parties and Bills of Lading, I decided that it was unlikely that my audience would be sitting there on tenterhooks, waiting to find out what my answer to that question might be. But as we are celebrating, albeit in somewhat muted fashion, the 125th anniversary of the Commercial Court, which has done so much to develop and promote English shipping law, I decided that this might be an appropriate occasion to consider 3 topics. First, how shipping disputes came to acquire their central role in developing English commercial law. Second, how the significance of shipping law has changed over the century and a quarter since the Notice as to Commercial Causes was published in February 1895. And finally, why shipping law remains central to the continuing strength and vitality of English commercial law today. Now, the first 100 years of the Commercial Court were dominated by shipping and international carriage of goods disputes. The principal practitioners were all shipping practitioners, and the great judges were all steeped in shipping law. I think about 80% of the nearly 300 cases reported in the first 5 volumes of the Times Reports of Commercial Cases are either shipping or marine insurance disputes. There was some ebb and flow in that work over the following decades. The long weekend of the 1930s appears to have been a relatively inactive period, and the 1950s likewise. But that flow of shipping work experienced a huge surge in the 1960s and 1970s, and was still going strong, albeit the tide was beginning to abate when the Commercial Court celebrated its centenary in 1995. Shipping law has played a key role in formulating the fundamental doctrines of English commercial law. For example, the law of discharge for contracts for breach was almost entirely hammered out on the anvil of shipping disputes. In cases such as Hayne versus Tate and Lyle, Chandris and his Branson Moller, the Simona, and of course the Hong Kong Fur. Shipping law provided that threefold classification of contractual provisions for the purpose of termination, the holy trinity of condition, warranty, and innominate term, which has provided English law with a flexible and calibrated response when determining what the consequences of non-performance by one party should be on the party's continuing contractual relationship. Many other legal systems, by contrast, for example, all those based on or similar to the Russian Civil Code, are still grappling with the issue of when breach will not simply excuse the obligation of counter-performance for so long as it may continue, or give a right to go to court for a judicially sanctioned termination, but actually provide a contracting party with the self-help remedy of terminating its contract. It was shipping law in the Swiss Atlantique which made it clear that termination for breach does not undo the effects of contractual exclusion and limitation clauses. Although it must, I think, fairly be acknowledged that it's shipping law which provides the last toehold for the otherwise discredited doctrine of fundamental breach through the increasingly arcane concept of deviation. Most of those cases which consider the circumstances in which a party faced with a repudiatory breach is not simply entitled, but effectively obliged to terminate the contract, also have a distinctly maritime flavour. For example, the Odenfeld, the Alaska Trader, and the Aquafaith. The doctrine of frustration, of course, was largely shaped by shipping law. The name derived from the maritime concept of frustration of adventure, and the dislocating effects of geopolitical crises on seaborne international trade have provided a steady stream of disputes in which the courts were able to refine and redefine that doctrine, with 2 world wars and numerous Middle Eastern conflicts combining to generate a significant body of authority. The law of remoteness of damage has an equally waterborne flavour. Hadley and Baxendale may only have involved an unsuccessful voyage across inland waterways, but it was the vagaries of seaborne trade against a background of rapidly fluctuating markets, which provided the classic formulation of the contractual rule in the Heron II, and the more controversial attempt to restate it in the Achilleus. Remoteness in tort has also been heavily influenced by developments afloat, albeit very often in that most treacherous part of any voyage, the dock. Maritime law has also made profound contributions to the law of illegality, estoppel, election, and with Sir Bernard Eder in attendance, I must also point out currency of loss and the Texaco Melbourne. One could multiply those examples endlessly. But the question is, why did shipping law prove so conducive to the development of those doctrines? It's relatively easy to see why English law achieved such a dominant position in international trade. As Lord Justice Scrutton, scion of a shipping and stevedoring dynasty himself, noted in Goss-Millard versus Canadian Merchant Marine Limited, England was the home of the courts of the greatest ship-owning country in the world. As Michael Collett QC has noted, that made England the place for cargo and chartering interests to bring suit against English domiciled shipowner defendants. And those shipowner defendants chose English law to govern their contracts. Those factors have generated a substantial body of case law, which was soon systematized in treaties and later collected in specialized law reports. But why did shipping law prove such a fertile ground for the development of commerce-friendly principles of private law? A number of possible causes suggest themselves. First, there is the nature and complexity of the maritime adventure. There are the vagaries of weather and navigation, the different methods of loading, stowing, carrying and discharging cargoes of vastly differing physical and commercial characteristics, the rise and fall of markets for both shipping and cargo, and of course the financial importance of the ticking clock, which forms an inevitable backdrop to any seaborne enterprise. These matters left ample room for things to go wrong, and for the parties to seek to allocate responsibility for those known and unknown unknowns through the terms of their contract. The matter has seldom been better put than it was by Lord Diplock in the Johanna Oldendorf, when he said this: "Despite the transformation that has taken place in shipping, in port facilities, and in communications during the last 400 years, the business nature of the adventure to which the contract between charterer and shipowner relates remains essentially the same. It is an adventure which of its nature has always been exposed to the risk of being prevented, impeded, or delayed by a variety of causes beyond the control of either party. If it is known in advance how loss due to delay from any particular cause is to be borne as between charterer and shipowner, account can be taken of the risk in fixing the freight payable. What matters from a commercial point of view is not so much that the risk should be borne by one party rather than by the other, but that it should be known at the time the charter party is made by which of them it will be borne." Some sense of the range of risks run in the maritime enterprise can be seen from the list of standard exceptions considered in Scrutton on charter parties and bills of lading. From the modest beginnings of exclusions of dangers of the sea only, we've reached a point where successive editions have claimed that an exhaustive enumeration is impossible. They embrace enemies within and without in the form of barratry, pirates, robbers and thieves, strikes in all manner of guises, leakage, ullage, spiles and jettison, the full Game of Thrones spectrum from fire to ice, and perils of the sea and a variety of mishaps on land. Those risks fall to be allocated not simply once and for all, as is often the case with contracts which are in the nature of an exchange, but to be allocated differently for those different stages of the voyage, famously differentiated by Lord Diplock once again in the Johanna Oldendorf: the loading or approach voyage, the loading operation, the carrying voyage, and the discharge operation. Another important factor is that certainly by comparison with other areas of commerce, such as banking and insurance, shipping transactions have come to be conducted against the background of a relative equality of bargaining power between those providing ships or carriage by sea and those utilizing them. I say relative because, of course, it cannot be forgotten that there was a period when, in Anthony Diamond QC's words, shipowners had been able to introduce into the small print on the reverse of their bills of lading exception clauses relieving them from an ever-increasing range of liabilities. That was a market failure which generated a variety of judicial and legislative responses, culminating in the Hague Rules of 1924, the Visby Protocol of 1968, and the Hamburg Rules. But charter parties, particularly in the 20th century, have been the subject of ebb and flow as the balance of commercial advantage has shifted between owning and chartering interests. The original standard forms tended to be produced by conferences of shipowners, such as the Baltic and White Sea Conference in Copenhagen in 1906, which originated the GenCon Charter Party, or the Chamber of Shipping Welsh Coal Charter Party of 1896, whose convoluted demurrage clauses proved such a goldmine to the legal profession. But these charters came to be modified through charterer involvement as in the Americanized Welsh Coal Charter Party of 1953, or they found themselves competing with more charterer-friendly rivals, such as the Baltimore Berth Grain Charter Party. The owner-friendly Baltime Time Charter had to compete with the NYP form, approved by the charterer-dominated shipping committee of the eponymous Commodity Exchange at 2 Broadway, New York. Other charter parties have been the product of joint effort. For example, the Chamber of Shipping River Plate or Centricon Charter Party, agreed between the UK Chamber of Shipping, representatives of the Argentine shippers, or the North American Grain or Norgrain Charter Party, a joint effort of BIMCO, the Chamber of Shipping of the United Kingdom, and the Federation of National Associations of Shipbrokers and Agents. The Warship Oil Void Charter Party was the product of the work of oil company executives seconded to the US government during the Second World War, and continued to be used by most oil majors for 10 years thereafter. But when rates turned firmly against owners, it was replaced by the oil majors' own charterer-friendly forms, such as the Esso Voy, Mobil Voy, and Texaco Voy charter parties. The oil majors also developed their own time charterer-friendly forms, such as the Shell Time form. But these standard forms are invariably supplemented by a lengthy list of bespoke rider clauses, which often exceed the printed terms in length. That is something unthinkable in the ISDA Master Agreement, and involves a much more significant degree of bespoking than seen, for example, in the Bermuda form insurance policy. The widespread practice of incorporating charter party terms into bills of lading, for example, through the Congen Bill, has ensured some beneficial spillover of the fluidity of charter party negotiations into the terms of the contract of carriage evidenced by the bill. The result is that shipping contracts are very often made by knowledgeable and evenly matched contracting parties, a contest in which the batting and the bowling is in a state of competitive equilibrium. There are, moreover, in most cases, repeat contractors on both sides. The great American jurist Carl Llewellyn noted the commercial imbalance which tended to follow when a repeat contractor was able constantly to revisit and revise a standard form, learning from its failure to achieve a desired commercial advantage in a way not open to its succession of one-time counterparties. As he put it in characteristic Llewellyn prose, the committed bargainer, defeated once and again, recurs to the attack. After each case, he can redraft and fight again. Further, in contrast with many other contracts, insurance being a particular example, the informational asymmetry in shipping transactions is far from unilateral. The shipowner is better informed as to the location, speed, and physical characteristics of its vessel. The shipper or charterer better understands the physical and commercial attributes of the cargo. While this no doubt explains the relatively limited contribution which shipping law has made to those parts of the law of contract concerned with defective consent, it has provided a sound platform on which to develop principles addressing breach, termination, causation, and damages. And in particular, it's avoided the imbalances seen, for example, in aspects of banking law, where the bank standard terms dominate, generating legal principles such as the law of contractual estoppel, which have not met with a wholly enthusiastic response. So I would suggest, therefore, there are a number of reasons why shipping transactions proved fertile ground for commercial disputes between competing interests. But what is it about the judicial response to those disputes which has met with such approval? Professor Francis Reynolds QC has suggested that the influence of shipping law has led to a rather strict law of contract, where the courts encourage people to stand by their rights and do not seek to grant relief merely because they disapprove or suspect, if fully informed, they would disapprove of the conduct of one party. Now, it is certainly the case that commercial judges have been resistant to any suggestion that legal doctrines operating outside the contract should be capable of modifying the operation of the parties' contractual rights. The example Professor Reynolds QC almost certainly had in mind when making his observation was the emphatic rejection by the House of Lords of the argument that the right to withdraw a vessel from service under a time charter for non-payment of hire should be qualified by the equitable doctrine of relief against forfeiture. It is also undeniably the case that English shipping law has always attached a particular premium to certainty. Lord Justice Robert Gough, when explaining in the Scattrade why there was no room for relief against forfeiture in a time charter party, explained the position as follows. It is of the utmost importance in commercial transactions that if any particular event occurs which may affect the parties' respective rights under a commercial contract, they should know where they stand. The court should, so far as possible, desist from placing obstacles in the way of either party ascertaining his legal position, if necessary with the aid of advice from a qualified lawyer, because it may be commercially desirable for action to be taken without delay, action which may be irreversible and which may have far-reaching consequences. It is for this reason, of course, that the English courts have time and again asserted the need for certainty in commercial transactions, for the simple reason that the parties to such transactions are entitled to know where they stand and to act accordingly. Indeed, the courts have fashioned legal doctrines so that they can facilitate immediate decision-making in the face of the inherently uncertain. That is an approach best captured by Mr. Justice Scrutt's judgment in Imbirikos and Sidney Reed & Co., when he said that commercial men must not be asked to wait to the end of a long delay to find out what in fact happens, whether they are bound or not. They must be entitled to act on reasonable commercial probabilities at the time when they are called upon to make up their minds. But whilst English shipping law has been strict in the way described by Professor Reynolds, it has not been unduly black letter or formalistic in its approach. I would suggest the defining hallmark of the response of English court decisions on shipping law disputes has been an approach to the issues with an informed understanding of where the risks of particular eventualities would ordinarily lie as between the two parties from a commercial perspective. The courts will then only sanction a departure from that allocation when an intention to do so is sufficiently clearly manifested in the contractual terms. There has, of course, been much recent judicial and academic emphasis on the collaborative nature of many types of contract, with the suggestion that their relational nature carries with it duties of good faith. And that topic was the subject of Vasanti Selvaratnam QC's Donald O. May lecture last year. Shipping contracts, of course, range from long-term time charter parties over many years to those for specific voyages, sometimes between parties whose dealings amount to nothing more than the exchange of the bill of lading. But I would suggest the defining approach of English shipping law, and one of the reasons for its great success, has been that it approaches these contracts on the assumption that they are not so much relational, but risk allocational. That approach is well captured in Mr. Justice Popplewell's observation in the Eleni P. as to the interpretive presumption with which issues of responsibility for delay under a time charter party is to be approached. He said time charterers give rise to particular considerations because of the allocation of risk which is inherent in their nature. Under a time charter, the risk of delay is fundamentally on the charterer, who remains liable to pay hire in all circumstances, unless exempt from doing so under an off-hire provision. Accordingly, the burden lies on a charterer to bring himself within the plain words of an exception from the obligation to pay hire, and all other things being equal, doubts as to the meaning of such exceptions are to be resolved in favour of owners. This approach, described as long ago as 1948 as a cardinal rule, has been articulated and applied in many cases, both before and since the recent House of Lords and Supreme Court cases on approach to construction generally. shipping and international trade law might be thought to abound with examples of the courts requiring a particular threshold of contractual clarity before holding there has been a departure from a well-established understanding of where risk or responsibility would ordinarily lie. These include the FOB buyer's obligation to make arrangements to ensure the ship arrives at the right time, the voyage charterer's non-delegable duty to provide cargo, the principle once on demurrage, always on demurrage, which weighs against the application of exception clauses to delay once laytime has been exhausted, the inapplicability of a charter party's exceptions during the vessel's approach voyage, and the presumption that a cessor clause will only operate to relieve a charterer for liability for freight when the ship owner is able to effectively exercise its lien. Mr. Justice Staunton observed of that last rule of construction in the Rio Claro, those who rely on the ordinary meaning of English words when drafting a contract or considering whether they should sign it may find themselves misled. They should have looked at Scrutton and Carver as well. But it is not for me to criticise such time-hallowed doctrines, which no doubt tend to avoid uncertainty and dispute. And who could doubt the wisdom of requiring those who draft charter parties to have a copy of Scrutton close to hand, and perhaps a copy of Carver as well? Another good example of this judicial method is the approach to bill of lading clauses, which it is argued relieve the ship owner from liability when it delivers otherwise than against production of a bill of lading. The obligation to deliver only against the production of the bill is one to which English shipping law has always accorded particular importance. The Court of Appeal in Michael Fielding Wolfe and Trinity Logistics stated it had long been a cardinal principle, and the courts have been noticeably hostile to the argument that contractual terms can relieve the ship owner of that liability. Indeed, so hostile have they been, one might begin to wonder whether there is any wording which would be capable of being found to have achieved that object. These cases exemplify a judicial judicial approach to the contract of carriage, in which the court's appreciation of the commercial understanding of the allocation of risk and responsibility informs the process of contractual construction and the hierarchy of contractual provisions. The recognition that for those who contract, not all contractual terms are created equal has been a distinct hallmark of English shipping law. It is one which has been particularly manifest when determining the relative significance of terms on the front and the back of bills of lading. That tendency in English law was already manifest by the time the House of Lords in Glyn and Margetson and Co. resolved that a broadly worded liberty to deviate clause in the printed terms had to give way to the main object and intent of the contract, the carriage of a perishable cargo between named places. It more recently reasserted itself in the House of Lords decision in the Star Sin, when identifying the carrier under a bill of lading. Lord Hoffman said that where the majority in the Court of Appeal had gone wrong was that they conscientiously set about trying, as lawyers naturally would, to construe the bill of lading as a whole, whereas in fact the reasonable reader of a bill of lading does not construe it as a whole. For some things he goes no further than what it says on the front. And a similar approach was adopted by the Court of Appeal in Trafigura Bahia versus Mediterranean Shipping Company, when rejecting the contention that a clause on the reverse of the bill released the claimants from liability for delivery without production of the bill of lading, because the basic obligation to deliver against an issued genuine bill of lading is given its own prominence on the very front of the bill. So central is the concept of allocation of risk and the desire to give effect to it, to English shipping law, that even outside the express terms of a time charter party, the court will often imply a right to indemnity as a further means of giving effect to the allocation of risk implicit in the commercial bargain. That was the subject of Lord Hamlin JSC's 2018 Donald O'May lecture, Under Charterer's Orders to Indemnify or Not to Indemnify. In that lecture, he referred to the implied right of indemnity as a striking example of the willingness of the commercial court to recognise and act upon accepted industry understanding. The court's assessment of the allocation of risk is central to the application of the right to an indemnity. Lord Sumption JSC explained the basis of the implication in the following terms in the costs. The owners are not entitled to an indemnity against things for which they are being remunerated by the payment of hire. There is therefore no indemnity in respect of the ordinary risks and costs associated with the performance of the chartered service. The purpose of the indemnity is to protect them against losses arising from risks or costs which they have not expressly or implicitly agreed in the charter party to bear. What risks or costs the owners have agreed to bear may depend on the construction of other relevant provisions of the contract, or on an informed judgment of the broad range of physical and commercial hazards which are normally incident to the chartered service, or on some combination of the two. Now, no one could plausibly claim that in quantitative terms, shipping law holds the same central place in English commercial law, which it did 50 or even 25 years ago. There are a number of reasons for this state of affairs, and not all of them are to be regretted. There are a significant number of shipping cases which arose from judicial attempts to work around structural failings in the common law, which have since been addressed by statutory interventions. Who but the most committed litigator could regret the demise of the large number of cases on the recoverability of economic loss, which to a significant extent flowed from the difficulties of transferring rights of suit in respect of cargo, since addressed by the Carriage of Goods by Siet 1992. The flood of cases resulting from the difficulty of conferring contractual rights on third parties, which led to the Himalaya Clause and the doctrine of Belmontant terms, has been significantly reduced by the Contracts Rights of Third Parties Act 1999. The reduction in cases of this kind is not a symptom of shipping law's decline, but the result of the successful application of a statutory balm to long recurrent common law irritations. The Arbitration Act 1996 has been another factor. In 1992, Professor Reynolds identified as one of the reasons for the prominence of shipping cases in English law the claim by English courts to review the decisions of arbitrators on points of law. While some, Lord Thomas, for example, have bemoaned the effect on the development of English commercial law of a more restrictive test for permission to appeal against arbitration awards on points of law, there seems no prospect of this being reversed. The burgeoning and indeed unstoppable number of disputes on arbitration law, which have helped fill the diary of the practitioner and the volumes of the law reports, are, I am afraid, but a poor recompense, a lex specialis essentially devoid of wider application or insight. But there are more arbitration appeals on points of law in shipping cases than any other type of arbitration. The London Maritime Arbitrators Association, unlike most arbitral institutions, does not include a waiver of the right to appeal on points of law in its rules. And the existence of the possibility of appeal on points of law at least of sufficient importance, or where the error is obvious, remains a singular and attractive feature of London shipping arbitration, a reflection of the mutual interest of members of the maritime community in retaining the ability to obtain a definitive ruling on points of significance. No doubt it's for that reason the Singapore Ministry of Law instituted a public consultation on whether to amend its own International Arbitration Act to introduce an opt-in provision for an appeal on points of law, specifically referring to the shipping community as possible users, albeit to date that proposal has not been implemented, and it's not clear that it will be. In addition, advances in the shipping industry have caused a decline in the volume of shipping litigation. Ships are larger, they're better built, and particularly after the introduction of the International Maritime Organization Code in 1998, by and large, they are better maintained. They are, moreover, increasingly specially constructed for the carriage of particular cargoes, rather than the general cargo carriers of yore. Heavy lift ships, reefer vessels, cement and car carriers, LNG and livestock carriers, and so on. weather reporting and routing are better, navigation with the benefit of satellite technology is more accurate, and general cargo is now almost invariably loaded, stowed, carried and discharged in containers rather than in break bulk form, making theft rather than damage perhaps a more significant source of outturned disputes. The reality is that carrying a delicate cargo in winter across the oceans has now become an activity with significantly better identified and therefore better managed hazards than investing in collateralized debt securities. Finally, litigation costs have increased at a greater rate than the average value of damaged cargoes, while the values in issue in other categories of dispute, failed investments, cross-border fraud, antagonistic business ventures in emerging markets have all grown. As a result, these new categories of dispute have proved more lucrative hunting grounds for litigators and advocates than the shipping stamping grounds which so attracted previous generations. So does that mean that shipping law has moved from the mainstream to what Lord Sumption described when handing down judgment in Volcafi versus Compagnia Subamericana as, and I quote, one of the obscurer corners of the law? My response to that, Aunt Sally, is no. Shipping law is still a context in which important legal principles are shaped and restated. The last 5 years have brought a number of significant cases. Very recently, we have K-Line versus Primin Shipping on the types of loss covered by liquidated damages clauses, a superb judgment by Mr. Justice Andrew Baker on its way to the Court of Appeal. There's classic Maritime and Limbungan on but-for causation and the ability to recover substantial damages in contract. The new Flamenco addressing which beneficial consequences of breach have to be brought into account when assessing damages. MSC Mediterranean Shipping and Cottonex Anstalt on the legitimate interest doctrine and whether and when it constrains a party's entitlement to keep a contract alive. Star Shipping and Grand China Logistics on the identification of conditions. The Global Santosh on agency and vicarious performance in chain contracts. And PST Energy versus OW Bunker on the identification of contracts of sale. If we extend our rearward view further, we soon find the Kos on bailment, the Rainy Sky, yet another milestone in the apparently endless battle between the purposive sheep and the literalist goats, and the Glory Wealth on the relevance of the unaccepted repudiation by an innocent party on the assessment of damages. In addition, although much reduced, the volume of shipping work in both the commercial court and in arbitration remains significant. For the year which has just ended on the 30th September 2020, over 100 shipping disputes were commenced in the commercial court, 200 claims were commenced in the Admiralty Court. Between them, about 20% of all claims commenced in both courts. A survey performed by Holman, Fenwick and Willan LLP, entitled The Maritime Arbitration Universe in Numbers, reported over 1,730 maritime arbitrations commenced in London in 2019. And although London is a major centre for arbitration of all kinds, the number of maritime arbitration here still significantly outnumbers the number of non-maritime arbitrations. But in any event, the significance of shipping law to English commercial law falls to be measured in more than merely the hard currency of decided cases and number of disputes referred to litigation or arbitration. Those who attempt to argue for the continued relevance of a post-imperial Britain in a much-changed world invariably point to the significance of its cultural and historical heritage and the soft power which that is said to bring. Whatever validity that argument may or may not have in geopolitical terms, we underestimate the value of the cultural heritage and soft power of shipping law at our peril. Shipping law remains essential to a proper understanding of many of the key doctrines of English law and of the cases in which those doctrines were formulated. Law students continue to have first contact with those doctrines by reading shipping decisions in which they were decided, and practicing lawyers continue to revisit them in that context, always finding something new in what were felt to be over-familiar cases. shipping law remains a valuable guide to understanding the architecture of English commercial law, which it did so much to create. It remains the first port of call for many commercial lawyers and commercial judges when looking for analogies to guide them on unfamiliar issues, or where searching for hard-edged and clear statements of the principle to apply to a dispute raising a similar issue in a very different commercial context. In 2020, 8 of the 13 judges of the Commercial Court are London Circuit Commercial Court. 3 of the 5 former Commercial Court judges in the Court of Appeal and 3 commercial judges in the Supreme Court have some shipping law in their professional backgrounds. I suspect if I was addressing a live audience at this point, I would see a number of quizzical looks as to who that third blue water Supreme Court judge might be. But I would urge those of you wondering not to forget Lord Burroughs' JSC's 2 tours of duty as an editor on the 20th and 21st editions of Scrutton on Charter Parties. The shared inheritance of shipping litigation provides a point of reference for judge and advocate well outside the limits of legal argument. I can recall coming close to the end of my time estimate in the Court of Appeal for Lord Justice Gross to tell me, much to the bafflement of my landlocked opponent, that my lay time was nearly up and that demurrage loomed and would be short. And in perhaps an even more irreverent example, an opponent asking the judge if the transcript writer's break could be taken early, because the barrister had an urgent need to deballast. In his 1997 Wilberforce lecture, entitled The Future of the Common Law, Lord Gough of Cheveley wrote that for the English, the characteristic commercial contract is a contract for the carriage of goods by sea. If we ask ourselves that question today, is that answer still true? Or would the answer now be the International Swap Dealers Association's master agreement? Or perhaps the oral joint venture agreement with a disputed choice of British law, without which no oligarch dispute in the commercial court would seem to be complete. In this lecture, I've offered my own thoughts as to why the contract for the carriage of goods by sea became the characteristic commercial contract in English law, and why it should remain so. Even though English shipping disputes no longer generate the volume of litigation they did in 1997, still less in 1895 when the commercial list came into being, or 1934 when Lord Justice Scrutton died in harness, shipping disputes remain essential to the proper understanding and future development of English commercial law. If I had adhered to the false controversy of my original title and asked, does shipping law still matter? My answer would have been emphatically yes.
Thank you, Sir David. It now gives me great pleasure to call upon Sir Bernard Eder to present the vote of thanks to our honoured speaker. Now, Sir Bernard is a man that needs little introduction to this audience, so hallowed, respected, and well known he is to all of us. But for any of you out there who are not aware, please see me later, Sir Bernard Eder is an international arbitrator and mediator now based at 24 Lincoln's Inn Fields in London. He previously practiced as a barrister at Essex Court Chambers, as we have heard from Sir David. He was appointed a judge of the High Court of England and Wales in 2011, during which time he sat mainly in the Commercial Court in London. He resigned from the bench in April 2015, and the same year was appointed as an international judge at the Singapore International Commercial Court. And he was reappointed for a further term in that position in 2018. He was formerly the senior editor of Scrutton on Charter Parties and the chair of ARISAS, the Insurance and Reinsurance Arbitration Society of the UK. And over the years, he has been appointed as an arbitrator in over 300 international arbitrations. Sir Bernard, to you.
Well, thank you, David. And David Foxton let the cat out of the bag by telling everyone that he was in fact my pupil many years ago. He was in fact a brilliant pupil then, and the magnificent lecture that he has delivered this evening is no more than a small glimpse of his breathtaking knowledge of the law. He was destined for the bench the moment he walked into my room at 4 Essex Court over 30 years ago. Anyone who has read any of his judgments will be astonished, not only by the speed at which they were delivered, but the impeccable reasoning and the sense of justice which leap off the page. As his former pupil master, I would like to think that everything he knows, he learned from me. But in truth, sadly, the opposite is much nearer the truth. Over the years, we worked together on a number of cases. The low point was probably the first report into the loss of the Derbyshire. But there were some triumphs, and our greatest triumph was surely persuading the House of Lords to reverse the decision of the Court of Appeal in the Dominique, when I was still a junior and David was still my pupil. In this, the 125th year of the creation of the Commercial Court, that court is indeed lucky to have David as one of its judges. According to Westlaw, in the 10 months or so that David has sat as a judge, he has delivered no less than 32 judgments. Only one has been reversed on appeal, and that simply because he was constrained to follow previous authority. You don't get better than that. You may not know, but apart from his great skills as a lawyer, scholar, and historian, David is also an accomplished singer. And whilst at the bar, I would often write a song, I suppose a ditty, at the end of a case to celebrate a great win or help drown the terrible sorrow of losing a case. So I thought I might share with you tonight this photograph. This is David and me at the Dorchester in, I think, 2005, at the end of a reinsurance arbitration in which we were both instructed by Peter Rogan at Ince. I think Peter, I spoke to him earlier today, is seeing this this evening, and I am sure he will confirm that this is not fake news. So this evening provides an opportunity for thanking David in the widest possible sense for the support he has provided to me, the learning he has shared, the friendship he has provided, and the fun that we have had together. And of course, for his magnificent lecture this evening. He has provided us all with a sweeping view of why shipping law has been so important to the development of English law in the past, and why it will surely continue to matter in the future. So David, on behalf of everyone tonight, thank you very much, and Godspeed in your judicial career. Thank you.
Thank you, Sir Bernard. I can hear, and I only regret that we all can't hear the resounding applause in the room for what has been an absolutely fantastic lecture. Sir David, thank you from the bottom of all of our hearts, not only for your words tonight, but your guidance and words in the Commercial Court. We have come to that moment of the evening when, although happy we have been to meet, we must now part, happy to meet again in the future. On behalf of Ince, I would like to thank our speakers this evening, both Sir David and Sir Bernard, the Faculty of Social Sciences and the Southampton Law School, Dr. Alexandros Dovas, the Director of the Institute of Maritime Law, our sponsor in formal law, and especially Laura Armstrong, Jo Hazel, Sophie Jones, and Claire Old, without whose support and invaluable assistance this event could not have taken place. As the dark winter nights draw in, I regret that we cannot now all share a cup together, but perhaps I could ask this of all of you. As you go to your rest this evening, may you find the time to drink a toast to the late and great Donald O'May. And I leave you with the words of Albert Einstein as a light that I hope will illuminate all of our paths over the weeks and months to come. In the midst of every crisis lies great opportunity. Thank you, one and all. Keep safe and good night. Thank you. Very well done, David.
Well done you as well. It's so strange, isn't it? This disembodied, speaking to a sort of disembodied audience, but we may have to get used to it. Bernard, thank you for that. I'm hugely touched.
Oh, there we are, David.